right, Tammy, I'm on. All right, good morning, Osceola County Jail. Can you hear me?
Yes, sir. Good morning.
All right, this is Judge Wooten. We're going to be handling matters for Division 201 and potentially some matters for other divisions. First up, Mr. Mills, tell me who your client is.
Judge, good morning. I represent Carlos Torres Carmona, case number 10CF3519.
Okay. Do you know if Mr. Carmona needs the assistance of an interpreter?
He does not.
Okay. Let's have Mr. Carmona come up.
May I approach with a plea form?
You may.
That's fine.
I'm just not seeing him on my docket. Oh, okay, now I found him. All right, come on up, Mr. Mills. Let's go ahead and swear in the defendant.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth to help you God?
Yes.
All right, good morning, sir. Tell me your name and your date of birth.
Carlos Torres Carmona, February 25th, 1981.
Sir, you've been charged by the state attorney's office in a 6-count information along with multiple co-defendants. Count 1 is dealing in stolen property, a second-degree felony, punishable up to 15 years in prison. Count 2 is burglary of a structure, a third-degree felony, punishable up to 5 years in prison. Count 3 is criminal mischief with damage of $1,000 or more, a third-degree felony, punishable up to 5 years in prison. Count 4 is grand theft in the third degree of $5,000 or more, a third-degree felony, punishable up to 5 years in prison. And count 5 is grand theft in the third degree, another third-degree felony, punishable up to 5 years in prison. And count 6 is criminal mischief with damage of more than $200, a first-degree misdemeanor, punishable by up to a year in the county jail. Sir, do you understand all those charges?
Yes, sir.
Standing here,
I'm going to need to interrupt the court on this, Judge. In speaking with the prosecutor assigned to the case, I thought we had agreed to 10 months. That was the offer that was conveyed to my client. That's what's reflected on the plea form. And now I'm being told that no, the offer is 366, which is a year and a day.
okay?
The ASA assigned to the case is ASA Maria Morales. She emailed me that the offer from the state was for pleas to counts 2, 3, and 4. The offer from the state is for an adjudication of guilt, 366 days DOC. The state would no cross the remaining counts, and there would be cost of investigation and restitution and cost of extradition that are required in this case.
So, Mr. Mills, what would you like me to do at this point?
We're either going to reset it for a plea or it's going to be put on a trial docket at some point.
Okay.
I'm assuming that my client does not want to plea to 366. Is that correct, Mr. Torres Carmona?
Excuse me?
There's apparently a misunderstanding as to the length of time that you would spend in the Osceola County Jail. I'm being told today that it's 366 days with credit for the time that you've got in.
That wasn't the deal.
Okay. So, Mr. Carmona, here's the situation. Your attorney was under one impression as to what the offer was, and that's what he explained to you. The prosecutor assigned to the case is not present in the courtroom. She's asked another prosecutor to handle the case. What that prosecutor was told is the offer is 366 days. So your choices are to reset this and let your lawyer get to the bottom of what's going on, where the misunderstanding is, unless you want to take 366 days right now to close the case out. I'm not suggesting you do that, but by the same token, if that's how you want to resolve your case, you don't want to reset this, and your lawyer's comfortable with that, then that's fine. If you want more time to talk to your lawyer and get to the bottom of the deal, that makes perfect sense to me. It's really your decision. It's not going to bother me one way or the other. So, do you understand the situation, number one?
Yes, I understand the situation.
And do you want to go ahead and take the 366 right now, or do you want to talk some more to your lawyer?
No, I want to talk to my lawyer some more.
All right, here's what we'll do. We will, Mr. Mills, I'm assuming that speedy trial is not an issue given the age of the case.
I assume so.
Okay. So at this point in time, I'm going to place this case on the pretrial docket that is set for Tuesday, June 23rd, 2020, and the trial period that's currently scheduled to start Monday, July 6th, 2020. And Mr. Mills, I'll have the deputies return your plea form. If you can get the confusion resolved, just schedule it for a new plea date with my assistant.
Okay.
All right.
All right, great, thanks.
Have a good day.
Thank you.
Mr. Seibel, do you have an inmate case?
Yes, Judge, good morning.
Okay.
Great to see you, Judge. Yes, we're here. I have Louis Christopher Penato Fadiol. That's 19 CF 2469, Judge. We were set for a bond motion, and thank you all so much for setting it so quickly. On my way over here, I realized that it got set so quickly that I got a witness or two that I really want to be able to present, take some testimony from, and I don't have them this morning.
Okay.
So with that, Judge, I spoke to the state. I know they have their victim who's on standby. I'd ask if we could just, if I could reset this, but I'm not sure what the state's position would be with their victim.
I mean, the victim he's going to appear telephonically whenever we have this hearing. That's not a problem. Given the limited nature of the defense's motion, though, I don't know what their witnesses would add, as the only issue raised by the defense is that due to coronavirus, the defendant who's being held proof evident or presumption great should be released. I don't know what that would add, as a full hearing's already been held on that.
I'm not going to tell Mr. Seibel how to present his case. He says he wants to reset the bond hearing so he can have some witnesses testify. He can reset the bond hearing. The witnesses will testify. You may be correct that at the end of the testimony, their testimony is not sufficient to change the court's position, but I'm not going to, in advance, deny Mr. Seibel the opportunity to bring witnesses and offer their testimony for whatever value it may or may not have.
Thank you, Judge.
Okay? All right, so I didn't actually see his case on the docket. Was there an add-on?
It was, Your Honor. It got added very late Friday, I believe.
Yes.
Okay.
Again, thank you all for the accommodation.
So here's what we'll do on Mr. Fatiel's case. Do we have dates as far as pretrial and trial for his case?
We do, Your Honor. It got continued to the July 28th pretrial, August 10th trial.
I'm simply going to take no action at this time on the emergency motion for pretrial release, and I'll have the clerk's note that it's going to be reset by the defense for a new hearing.
Thank you, Judge. We're going to reach out today for some dates this morning so we can try to get my witnesses here ASAP.
Okay, and one thing I want you to explore is the potential for witnesses appearing telephonically. You can talk to the state about that.
I have no objection to that.
So we just need to make sure that we've got some way to properly identify them.
One's a professional and one's a layman, your judge, so I think we can make that happen.
Okay, I guess the issue is going to be is, and also with the victim, what's y'all's position going to be on administration of oaths when they're appearing telephonically?
I believe the rule from the Florida Supreme Court that's come down is wherever they are, as long as they're within the United States, I believe they're subject to sworn testimony and perjury. So I think under the order from the Florida Supreme Court, they can have their oath administered by the clerk of court telephonically.
I think the only potential challenge is nobody's really argued about this at this point in time, is whether there's an adequate way to confirm the identity of who is on the line. Because the Supreme Court order suggests that there's some way, or that determination needs to be made. It doesn't really give us guidance on exactly how that's supposed to be done in the telephonic matter. So again, no one's really been worried about it at this point in time. They've not raised any objections at this point in time. It's just something that potentially, depending on the nature of the testimony, it could become an issue. So I'm just throwing that out there as another one of these details that we need to wrestle to the ground and be thinking about before we get in the midst of a hearing.
Yes, Judge.
Okay? So, all right. We will reset, or we'll await the defense resetting Penado Fatial.
Thank you, Your Honor. Great to see you.
Okay, all right, good seeing you. Okay, so let me just take a look through this. All right, it looks like everybody on the docket this morning is represented. So, Ms. Cobb or Ms. Rosas, do y'all have a preference whose cases get called?
Judge, I have a plea
Okay,
today. It's a plea date certain. I haven't, I'm not sure what your position is. I haven't received the signed copy from Mr. Jones. I can reset it, make sure that he signs the plea form. But I think what we've been doing in Judge Morgan was take a plea form here with the state attorney, and then his plea form will come in.
right, as long as I have a plea form that memorializes the outcome and he acknowledges that he signed a form that basically says the same thing, I'm comfortable taking the plea in those circumstances. So tell me who the defendant is.
His name is Charles Jones. You have a plea form?
Let's have Charles Jones come up. Morning, let's go ahead and swear Mr. Jones in.
Can you raise your right hand, please? You do solemnly swear or affirm the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir. Yes, ma'am.
Morning, sir. Tell me your name and your date of birth.
Charles Jones, 1982.
Mr. Jones, as you stand here today, you're currently charged with 3 crimes. Each is a count of cruelty to animals. Each of those is a third-degree felony. Each of those is punishable up to 5 years in prison. Do you understand that?
Yes, sir.
Standing in here in the courtroom is an attorney from the Office of the Public Defender who's indicating that you are going to enter a plea today. Is that correct?
Yes, sir.
Ms. Cobb, what is the proposed resolution in this case?
It's an adjudication of guilt, 10 months in the Osceola County Jail. That is to be run concurrent with case number 17 CF 2886.
And we're showing that he currently has 112 days time served. Is that your understanding?
I counted 113 plus today. I guess I would add to. Oh, no, 112. That's correct. On 17 CF 2886, he has 113 days. We've discussed the discrepancy, and he still wants to. I mean, it's not a discrepancy, but.
Do you
But in
have,
this case, it's 112. Yes, sir.
do you have the plea form?
I do.
All right, approach, please.
And Judge, I also have the score sheet.
Okay. State, is this the agreed resolution?
This is the agreement of the assigned Assistant State Attorney Maria Morales. I'm here to facilitate that, so this is her agreement, yes.
Okay. And Mr. Jones, is this how you want to resolve your case today?
Yes, sir.
As you stand here today, are you under the influence of any drugs, alcohol, or other medication?
No, sir.
Have you ever been treated for a mental illness, emotional disturbance? Are you suffering from such at this time?
No, sir.
Do you read and understand the English language?
Yes, sir.
In this courtroom, I have been given a document called a plea form. I'm going to hold it up. I know you can't see the writing on it, but it's a 2-page document. It's printed front and back. It has your name on it, your case number on it, the charges you're pleading to, the resolution, and all of your rights. Did you go over a form like that out at the Osceola County Jail?
Did I go over a phone?
Yes.
Judge, we talked about it over the phone.
I talked over on the phone.
Okay, so did your lawyer explain to you each of these paragraphs on the form?
Yes, sir.
All right. And have you signed a plea form at this point?
No, sir.
Okay. Did your attorney answer any questions you had about all of the rights in this case?
Yes, sir, she did.
And do you understand that part of this process is they're going to present this form to you so you can sign it? Do you understand that?
Yes, sir.
And understanding all of the rights in this form, have you decided it's in your best interest to enter a plea?
Yes, sir.
Do you understand by entering a plea, it means we're not going to have a trial in your case, and I will sentence you today?
Yes, sir.
Has anyone forced, threatened, or coerced you to enter this plea?
No, sir.
Other than what's been discussed here in the courtroom, has anyone made any other promises to you about the sentence you would receive?
No, sir.
Are you satisfied with the work the public defender has done in handling your case?
Yes, sir.
Do you understand, sir, if you were not a citizen of the United States, entry of this plea would result in your deportation?
Yes, sir.
Will the state attorney please provide a factual basis for the 3 counts?
Your Honor, the factual basis that's been provided to me by ASA Morales is that on or about August 19th, 2016, while executing a search warrant at the defendant's house, law enforcement discovered 7 dogs outside of the home that were in makeshift crates attached to heavy chains in areas riddled with safety hazards and covered in feces. An exhibit called Exhibit B had a lot of dog fighting wounds and was missing, I guess a dog had a lot of dog fighting wounds and was missing an ear, which were signs of repeated infliction of unnecessary pain. Another dog had fighting wounds and abrasions on its paws, clearly causing great pain and discomfort. And a third dog had serious skin infection, which also caused unnecessary suffering to that animal. This all happened in Osceola County, Florida.
Ms. Cobb, any objection to that factual basis for purposes of this plea?
No objection.
All right, Mr. Jones, I'm going to accept your plea. I find you're alert and intelligent. Your plea is freely and voluntarily entered. You understand the nature of the charges against you, and you're represented by competent counsel with whom you say you're satisfied. I also find a factual basis for the acceptance of the plea. Is there any legal reason why sentence should not now be imposed, Ms. Cobb?
No, sir.
State anything else.
Nothing further personally known to me, Your Honor.
All right. Mr. Jones, the court having accepted your plea on each of the 3 counts, I'll adjudicate you guilty. On each count, I'll sentence you to 10 months. That's 300 days in the Osceola County Jail. On each count, I'll give you credit for 112 days time served. Each count will run concurrent with the other, and it'll run concurrent with the sentence that you've already received in the case number previously announced by the public defender, 2017 CF 2886. I'll also order that you pay all statutorily required fines, fees, and costs associated with this plea. Madam Clerk, can you announce those costs?
The $415 court costs, a $3 teen court fee, $100 cost of prosecution, $100 PD lien, $100 PD assistance fee for a total of $718.
All right. Sir, how long did you get on the 2017 case? How much time did they give you on that case?
10 months.
Okay, all right. So if I gave you 60 days from the date you get out of custody to get out, find a place to live, start working, any reason you can't pay $30 a month towards your cost?
Yes, sir. I already have a job. I can pay it.
Okay, so here's what I'll do. On this case, I'll order within 60 days of your release of custody, you contact the clerk of the court, set up a payment plan, and begin making payments at a minimum rate of $30 a month towards your cost until your costs are paid in full.
Yes, sir. Thank you.
You're welcome. Anything else from the public defender?
No, sir.
Anything else from the state?
No, Your Honor.
Anything else from the clerk?
No, sir.
That's the judgment. Since the court, defendant will be fingerprinted at the Osceola County Jail, and a plea form will be presented to him for his signature. Okay. So question, Ms. Cobb, is this plea form that you gave me getting filed here?
Yes,
Okay, all right,
and I'll follow up and make sure he.
okay. Ms. Cobb, what else do you have this morning? Wow. Must be nice to be a senior attorney.
ASA Baines counsel, I'll hear that.
All right, Ms. Rosa, so I'm guessing you've got everything else?
I guess so. I guess I'm covering for some people.
Okay.
No.
Oh, okay. All right. Yes, I guess I have everybody else.
So let me ask you this. Is there a particular order you'd like to call the case, or do you just want me to go through the docket?
Well, we can just go through the docket because we have the arraignments first.
Okay.
Okay.
So let's go ahead and run through our arraignment docket. The first case I'm showing is Brian Michael Klein, an arraignment for Division 101.
Yes, Your Honor. In this case, I'm covering for Mr. LeBay. We'll waive his arraignment and enter a plea of not guilty.
Okay. Do we have dates for Division 101?
Yes, sir. It's going to be pre-trial August 12th, trial August 24th.
All right, Mr. Klein?
Yes, sir.
All right, you're set for trial in Division 101. Your pretrial date again is August 12th, and your trial period will start
24th.
August 24th. The Office of the Public Defender is representing you, and they've entered a plea of not guilty on your behalf, okay?
Okay, I thought I had the pre-trial June 16th.
Those are the dates that I have been given by Judge Morgan. So you can contact your assigned public defender if there's some confusion and follow up to see what the situation is, okay?
Okay.
All right. Next, I have Cassandra Osborne.
In this case, I'm covering for Mr. Johnson. Mr. Johnson waived her arraignment and entered a plea of not guilty on her behalf.
Do we have dates for Ms. Osborne?
They need to be set.
Okay. Let's do this. On Cassandra Osborne, I'm going to set her for pretrial conference on September 2nd, and a trial period starting October 19th. Oops, that's not right. September 2nd, and a trial period starting September 14th. All right, next I have, Mr. So, I'll take care of you in just a minute, all right? Next I have Andrew Santos.
In this case, I'm covering for Ms. Kronk. We would waive his arraignment and enter a plea of not guilty, or enter denial.
All right, looks like he's got two separate cases, correct?
Yes, Your Honor. We would enter denials in both.
All right. All right, we'll enter denials in both cases. What dates has the clerk given?
Status hearing is August 18th. The VOP status hearing, August 18th. VOP hearing scheduled for August 20th, both cases.
That's strange. You said August 18th?
Yes, sir.
Are these not my cases?
No, they're 101,
Oh, okay.
Morgan's cases.
8/18
820.
and 8/20. Okay. All right. Mr. So, good morning. You have Dustin Jones, is that correct?
Yes, Your Honor.
That case is docketed for plea today, is that correct?
Yes, sir. That's right, Your Honor.
Let me ask you this. Has a plea form been submitted to the clerk, or do you have it with you?
I have it with me when I'm over with my client.
Have you completed that, or you need to go over it?
I went over it with them, completed the initial every page and signed it.
Okay. All right. And who's the state?
Andrew Bain for the state of Florida, Your Honor.
All right. And Mr. Bain, are you ready to proceed with the plea?
Yes, Your Honor.
Can I get a folder on Mr. Jones? All right, let's go ahead and swear Mr. Jones in.
You do solemnly swear or affirm the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, good morning, sir. Tell me your name and your date of birth.
Dustin Wayne Jones, October 21st, 1989.
Mr. Jones, you are currently charged with 5 crimes. Count 1 is trafficking in 28 grams or more of methamphetamine with a weapon. That's a life felony in the state of Florida. A sentence of life means just that. You spend the rest of your natural life in prison, and there's a 7-year minimum mandatory sentence associated with that count. A minimum mandatory sentence is, you should assume, if it's imposed, that you serve each and every day of that minimum mandatory sentence. You should assume it doesn't qualify for any time of good, gain time, or early release time. Count 2 is possession of a firearm by a convicted felon. That's a second-degree felony, punishable to 15 years in prison. There's a 3-year minimum mandatory associated with that. Count 3 is carrying a concealed firearm, a third-degree felony, punishable to 5 years in prison. Count 4 is resisting officer without violence, a misdemeanor of the first degree, punishable to a year in the county jail. And count 5 is loitering or prowling, a second-degree misdemeanor, punishable by up to 60 days in the county jail. Do you understand the 5 crimes you're charged with, sir, and the maximum possible punishment you are facing?
Yes, sir.
Mr. So, can you tell me what the proposed resolution is?
The proposed resolution is 3 grams meth, which carries a minimum mandatory of 3 years in prison, and it's a first-degree felony. It's a statute number 893.135, subsection 1, subsection F, 1B, Your Honor.
1F, 1B.
Yes, Lord.
Okay?
And count 2 is plea of charge, possession of firearm by convicted felon, 3 years minimum mandatory. And the proposed resolution is 3 years in prison, the minimum mandatory sentence, to run concurrent, $50,000 fine, which is the mandatory fine for count 1, and no cost in remaining counts, and 4 costs and cost of investigation and cost of prosecution.
Are those amounts, are the cost of investigation amounts agreed to?
It's just, there was no cost of investigation in this case.
Okay. State, is this otherwise your agreement?
Yes, Your Honor.
Do you have a score sheet for me?
Yes, Your Honor.
Mr. So, have you reviewed the score sheet?
The previous one before it was reduced, Your Honor. Yes.
All right, and any objections to the score sheet?
No, Your Honor.
All right. Mr. Jones, is this how you want to resolve your case?
Yes, sir.
As you stand here today, are you under the influence of any drugs, alcohol, or other medication?
No, sir.
Have you ever been treated for a mental illness, emotional disturbance? Are you suffering from such at this time?
I have not, or am not.
Do you read and understand the English language?
I do.
Your attorney has indicated that he has gone over a document, he's holding it in his hand right now, called a plea form. Does that document look familiar to you?
Yes, sir.
Did you go over this document with Mr. So?
Yes, sir.
Did he explain to you all the rights you have and the rights you're giving up by entering this plea today?
Yes, sir.
Did he answer any questions you had about your rights?
Yes, sir.
Did you then go through the document, initially in each paragraph, indicating that you read and understood what was explained in that paragraph?
Yes, sir.
Did you sign on the last page?
Yes, sir.
Do you understand that you're entering a plea today, which means we will not have a trial in your case, and I will sentence you this morning?
Yes, sir.
Has anyone forced, threatened, or coerced you to enter this plea?
No, sir.
Other than what's been discussed here in open court, has anyone made any additional promises to you about the sentence you'd receive in this case?
No, sir.
Are you satisfied with the work Mr. So has done in handling your case?
Yes, sir.
Do you understand, sir, if you were not a citizen of the United States, entry of this plea would result in your deportation?
Yes, sir.
State factual basis, please.
Yes, Your Honor. On September 2nd, 2019, in Osceola County, Florida, law enforcement got a tip that Sadie Wells was going to be selling narcotics at 5870 West Earl Bronson Highway. Law enforcement positioned themselves across the street from the business. They observed a car approach and park. Defendant Wells was the front seat passenger of that vehicle. There are other persons in the vehicle, but Mr. Jones was a rear seat passenger. Law enforcement exited a mere unmarked vehicle, began to approach the individuals at that point, exited the vehicle. Law enforcement at that point, Mr. Jones saw the law enforcement approaching, had an object in his hand, threw it underneath the vehicle. Law enforcement then tried to detain and talk to Mr. Jones. Mr. Jones then fled from them. They gave him lawful orders to stop. He then was tasered by law enforcement. Search engine of lawful arrest observed a trafficking amount of 33 grams of methamphetamine inside of Mr. Jones' pants. The object underneath the vehicle was discovered to be a firearm. The defendant, Mr. Jones, was convicted of a felony prior to this date. All these things happened in Osceola County, Florida.
Mr. So, any objection to that factual basis for purposes of today's plea?
No, Your Honor.
Mr. Jones, I'm going to accept your plea. I find you're alert and intelligent. Your plea is freely and voluntarily entered. You understand the nature of the charges against you, and you're represented by competent counsel with whom you say you're satisfied. I also find a factual basis for the acceptance of the plea. Is there any legal reason why sentence should not now be imposed, Mr. So?
No, Your Honor, and we withdraw the motion to suppress on this case, Your Honor.
All right. Mr. Jones, you understand that by entering the plea today, we're not going to have a motion to suppress that was previously filed. You understand that?
Yes, sir.
All right. Sir, the court having accepted your plea, I'll sentence you as follows. On count 1, as to the lesser included offense of trafficking in 14 or more grams of methamphetamine, but less than 28 grams, I will adjudicate you guilty. I'll sentence you to 3 years in the Department of Corrections. That's a minimum mandatory sentence for that violation of the drug trafficking statute. I'll give you credit for 268 days time served. I'll order that you pay a $15,000 statutorily required fine.
50,000, Judge.
50? 50?
50.
Mr. So, you agree 50?
Yes, Your Honor.
That's a $50,000, 50,000 fine, along with any other required fees and court costs. We'll get the total in a moment. If I did not say, I'm giving you credit for 268 days time served. And then on count 2, I'll adjudicate you guilty of the offense. I'll sentence you to 3 years in the Department of Corrections with credit for 268 days time served. The sentence on count 2 is concurrent with the sentence on count 1. And again, I'm ordering that you pay all other statutory required fines, fees, or costs, along with the $50,000 fee. Although, Madam Clerk, I believe because there's a $50,000 fine, the drug case fine does not apply because the $50,000 is greater. What are the other costs, Madam Clerk?
$415 court costs, a $3 teen court fee, $100 cost of prosecution, and the $50,000 fine with a $2,500 surcharge for a total of $53,018.
All right. Mr. Jones, I'm going to order within 90 days of your release from custody, you contact the clerk of court here in Osceola County, set up a payment plan, and begin making payments at a minimum rate of $75 a month towards your costs till your costs are paid in full. State, do you have an announcement on counts 3, 4, and 5 of the information?
State announces the non-processing counts 3, 4, and 5 only, Your Honor.
Anything else, State?
No, Your Honor.
Anything else, Mr. So?
I believe Mr. Jones wanted to see if Your Honor could order him to a work camp at the Department of Corrections, Your Honor.
I don't have any authority to direct the Department of Corrections to place him in a particular location. State, do you have any objection if I announce that I have no objection to him being placed?
No, Your Honor.
What I will do, sir, is I'll have the clerk put in the sentencing paperwork that the court has no objection to the Department of Corrections placing the defendant in a work camp program if they screen him and if they deem it an appropriate placement. Okay? All right. Defendant will be fingerprinted at the Osceola County Jail, and Mr. So, you need to make sure that the plea form gets filed with the clerk of the court. I've got the rest of the paperwork here in the courtroom. Anything else, Mr. So?
No, Your Honor.
Anything else, Madam Clerk?
No, sir.
All right, that's the judgment. Sentence the court. Defendant's remanded to the custody of the Department of Corrections at this time. You're welcome. All right, so here's Jones's paperwork. All right, do we have any other private attorneys who are out at the jail?
No, Your Honor.
Okay, so Ms. Rosas, can we resume calling through the public defender docket?
Yes, Your Honor.
I'm showing an arraignment on, looks like Christopher Mark Schoonmaker.
Yes, Your Honor. I'm covering for Ms. Hernandez. In this case, we would waive his arraignment and enter a plea of not guilty.
Okay. Good morning, Mr. Schoonmaker. The Office of the Public Defender has waived your appearance at arraignment this morning. They've already entered a plea of not guilty on your behalf. Do we have court dates for Division 101?
It would be the same date, so it would be August 12th and August 24th.
All right, Mr. Schoonmaker, you're going to be set for pretrial conference on August 12th and a trial period starting August 24th. Again, the public defender in Division 101 assigned to your case will follow up with you, okay? All right. Next, I have a motion for automatic release ROR on Ronald Jackson.
Yes, Your Honor, that's one of my cases. In this case, I'm not sure if the state has filed an information yet.
It has no objection to the 33-day ROR.
All right. Good morning, Mr. Jackson. The state attorney's office has not yet filed an information against you, and therefore I'm going to grant your motion for ROR in this case. Now, one thing you need to understand, Mr. Jackson, when I release you ROR, one of your obligations is to make sure the clerk of the court has an updated address. Do you understand that? If you get out of jail and you don't update your address and the state attorney files charges against you, the clerk's going to send a notice to your last address. If you're not getting your mail there, you're not going to get it, are you? And then what's going to happen when you don't get your notice? I'll issue a warrant for your arrest if you don't come to court. So make sure you have an updated address with the clerk and stay in touch with the public defender's office, okay? All right. Defendants, you're welcome. He's released ROR at this time, in this case only. All right, that takes care of that. That takes care of that. I have Hernanin Alexis Rios Rodriguez. That's set for a bond hearing.
Yes, Your Honor, in this case, we need an interpreter.
All right, can we hold that defendant for a moment, actually? I just want to get through the rest of the cases, then I'll get the interpreter. All right. And then, has anybody had contact with Attorney Daryl Smith?
I have not. Which case is that on here?
That's on Anthony Weeks. It's listed for a plea date certain.
I was told by ASA Morales, Your Honor, that Mr. Weeks has not arrived at the Osceola County Jail yet, so it'll have to be reset anyway, but I have not had any contact with the assigned attorney on the case.
Osceola Corrections, do you have Anthony Weeks present?
No, Your Honor, he's in Sarasota.
Okay.
Corrections.
All right, then we'll simply reset that case. Thank you. Ms. Roses, are you going to handle Sean Kelly?
Yes, Your Honor. I represent Mr. Kelly in 19 CF 1344, 1347, 643, and 645. I know that he was represented by Regional Conflict Counsel in 646. I reached out to Regional Conflict Counsel and let them know about the court date today, but he just said that he had withdrawn, so he wasn't, that's why he's not present. But Mr. Kelly would like to go forward with that plea pro se.
Okay. Tammy, do you know if, I'm sorry, Ms. Roses, tell me that case one more time.
It was 19 CF 646.
On 19 CF 646, do you know if there's actually been an order appointing conflict counsel? RCC apparently has moved to withdraw. So did I assign somebody off the registry?
No, sir.
Okay.
The last order was RCC back on May 5th.
Are you showing that they filed a motion to withdraw?
Yes, they did file. They filed on May 7th.
Okay, all right. But I haven't signed an order yet.
No, sir.
Okay, all right. Let's go ahead and swear,
Print it out and sign it, but
well,
I guess.
we'll just make sure the court minutes are crystal on that case. Can I have his files? Let's go ahead and swear Mr. Kelly in.
Raise your right hand, please. You do solemnly swear or affirm the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, good morning, sir. Tell me your name and your date of birth.
Sean Kelly, November 17, 1980.
Mr. Kelly, you have multiple cases before the court. In 2019 CF 1344, you're charged with one crime. That's a crime of grand theft in third degree. It is a third degree felony, punishable up to 5 years in prison. In 19 CF 1347, you're charged with 2 crimes. The count 1 is another grand theft in the 3rd degree, and count 2 is another grand theft in the 3rd degree. Each of those are punishable by up to 5 years in prison. In 19 CF 643, you are charged with 1 crime. Just give me a second. That's the crime of grand theft in the 3rd degree. Again, punishable up to 5 years in prison. In 19 CF 645, you're charged with 1 crime, the crime of grand theft in the 3rd degree, punishable up to 5 years in prison. And in 19 CF 646, you are charged with 1 crime, grand theft in the 3rd degree, a 3rd degree felony, punishable up to 5 years in prison. Do you understand all the crimes you're charged with in these 5 cases?
Yes, sir.
Now, in case number 19 CF 646, you originally were represented by the public defender. They withdrew. Then the Office of Regional Conflict Counsel was appointed. They filed a motion to withdraw because they have a conflict. It's my understanding that you would like to represent yourself on the plea in 19 CF 646. Is that correct?
Yes, sir.
All right. So the court minutes will reflect in 19 CF 646 that I'm granting the motion to withdraw by the Office of Conflict Counsel, and the defendant is indicating that he wants to represent himself on that plea pro se. Mr. Kelly, do you understand that you have a right to have a court-appointed attorney if you can't afford one, and I'm happy to appoint another attorney to represent you and have them look at your case. You understand that?
Yes, sir.
You understand you're giving that right up by entering this plea today?
Yes.
And have you decided that's the best thing for you to do?
Yes, sir.
Okay. So, Ms. Rosas, what is the proposed resolution for all of the cases?
So as to 19 CF 643, 645, and 646, Mr. Kelly will be entering pleas of no contest, and the agreed upon sentence is an adjudication of guilt, credit time served, and court costs. And in 19 CF 1344 and in 1347, it would be, he would be entering pleas of no contest, and the agreed upon sentence is an adjudication of guilt, credit time served, followed by 18 months probation, with the condition that he complete the drug treatment program at Foundations for Life and court costs, and the state does not have any objection to early termination after 9 months once his program is completed.
Is Foundations for Life considered a residential program?
Yes, Your Honor. And they actually emailed me today and let me know that they have a bed available for him.
Okay.
There'll be restitution and cost of extradition on cases.
Right, and there's also restitution.
Reserving as to amount?
No, Your Honor, it's a specific amount.
What's that restitution amount?
In which case? Which case?
Would it be, I mean, I guess just all the cases, right? Doesn't he have?
Right, each case is going to have a different restitution or cost of investigation amount. In case 19 CF 1344, it'll be restitution of $549, no cost of investigation. In case 19 CF 1347, it'll be $1,436 restitution, no cost of investigation. In case 19 CF 643, it'll be $2,994 restitution, joint and several with the co-defendant, and cost of investigation of $360. In 19 CF 645.
All right, let me interrupt. You said on 643, you said how much?
On 643, it's $2,994 restitution and cost of investigation of $360.
All right, the order on investigative costs in 643 reflects $643.
I believe it should be 360. That must be an error when I typed it in.
Do you want to, I'll give you the order back, you can amend it?
Yes, sir.
Okay. What about case number 645?
On case 645, it'll be restitution of $798, joint and several with the co-defendant, and cost of investigation of $268. And then on 646, it'll be restitution of $1,856, joint and several with the co-defendant, and cost of investigation of $130.
Okay. Was there any agreement about how much he would pay each month towards restitution?
No, Your Honor, that was never discussed, but I would just ask that he be put on a payment plan.
I will, but I need to have a conversation with about how much that payment plan is going to be. Okay. Mr. Kelly, do you understand that that's the resolution in your cases?
Yes, sir.
And is this how you want to resolve your cases?
Yes, sir.
As you stand here today, are you under the influence of any drugs, alcohol, or other medication?
No, sir.
Have you ever been treated for a mental illness, emotional disturbance? Are you suffering from such at this time?
Yes, sir.
Do you read and understand the English language?
Yes, sir.
Your attorney in each case has filed with the court a document called a plea form. The forms are identical. The only difference is there's one for each case with that case number on it. It says what charges you're pleading to, and it has the proposed resolution for that case. Did you go over these forms?
Yeah, sure did.
Did you have an opportunity to speak to Ms. Rosas about the rights set out in these forms?
Yes, sir.
Did she answer any questions you had about your rights?
Sure did.
Did you then go through each form, initialing the form, indicating you understood what was explained in the paragraph?
Yes, sir.
Did you sign the last page of each form?
Yes, sir.
And on the 4 cases where she represents you, have you decided that's the best way for you to resolve your case is the resolution announced in court?
Yes, sir.
On the case where you're representing yourself, do you understand that all the rights you have in those other 4 cases you'd also have in the case you represent yourself?
Yes, sir.
Have you decided in the case where you represent yourself, the best thing to do is take the state's time served offer?
Yes, sir.
All right. Has anyone and do you understand by entering these pleas, number 1, we're not going to have a trial in any of these cases. Do you understand that?
Yes, sir.
Number 2, you're agreeing to pay the restitution amounts that were announced here in court. Do you understand that?
Yes, sir.
So we're not going to have a hearing on that issue. Do you understand that?
Yes.
And then you're also agreeing to pay the cost of investigation amounts that were announced on the cases where they applied. Do you understand that?
Yes, sir.
Which means we're not going to have a hearing on that.
Yes, sir.
And again, have you decided this is the best way to resolve the case?
Yes, sir.
Has anyone forced, threatened, or coerced you to enter these pleas today?
No, sir.
Other than what's been discussed here in open court, has anyone made any other promises to you about the sentence you'd receive in this case?
No, sir.
Are you satisfied with the work that the public defender has done in the 4 cases where she represents you?
Yes, sir.
Do you understand, sir, if you were not a citizen of the United States, entry of these pleas would result in your deportation?
Yes, sir.
State factual basis for each of the cases.
Your Honor, I inquire if the defense would stipulate to a factual basis as to each case.
We'll stipulate, Your Honor.
Or would accept the stipulation.
Well, let me ask you this, Mr. Baird. Are you indicating that you believe the affidavit filed in each case is sufficient to establish the elements of the charged crimes?
Yes, Your Honor.
And Ms. Rosas, are you conceding that the affidavit filed in each case has sets out sufficient facts to support a finding that the defendant committed the crimes charged?
Yes, Your Honor.
All right. I think I can rely on the affidavits in the court file as a factual basis to accept a plea as long as there's no objection. So, Mr. Kelly, I'm going to go ahead and accept your plea. I do find a factual basis for each plea based on the affidavit that was filed in the case. I find you're alert and intelligent, and you're represented by competent counsel with whom you say you're satisfied. Is there any legal reason why sentence should not be imposed in any of the cases, Ms. Rosas?
No, Your Honor.
State?
None personally known to me.
And do we know, is there a criminal punishment code score sheet in one of the files that has all the cases?
I did hand one to Madam Clerk. I think that's the global score sheet.
Is it in one of these cases?
Oh.
All right, just so I can get through this, I'm pulling the necessary paperwork out of each case. There it is, I found it. All right, Mr. Kelly, just give me 1 second, and we'll go through each case and announce your sentence. There's your score sheet. Starting in case number 19, CF 1347. In that case, I will adjudicate you guilty on each of the 2 counts. On each count, I will sentence you to 162 days in the Osceola County Jail. That's going to be followed by 18 months of supervised probation. Sir, is there anything that's going to hold you in the Osceola County Jail other than these 5 cases that we're resolving today?
I don't believe so.
Okay, so I'll order that you report to Department of Corrections probation no later than Wednesday, May 27th by 4 p.m. If you get out in time today and go today. If you can't, make sure no later than 4 p.m. tomorrow. While you're on probation, I'll order that you enroll in and successfully complete the Foundations for Life residential drug treatment program. Order as a condition of probation that you be subject to random drug testing. I'll order that you not possess or consume any illegal drugs while you're on probation. I'll note that the state has no objection to an early termination once the program is completed, as long as you have served at least 9 months of your sentence. Now, this question for the state and for Ms. Rosas. Typically, when I get a motion for early termination, one of the first things I do is check to see if there's any outstanding restitution. So I guess, Ms. Rosas, your client needs to understand that if there's outstanding restitution, I'm unlikely to grant his motion for early termination. Mr. Kelly, you understand that?
So it has to be paid in full, or can it be still with the collections?
Well, I'll look at what you've done and I'll make a determination. But here's the thing I want you to understand. There's no guarantee that I'm going to early terminate you at the 9-month mark just because you've completed the program. I'm still going to look and see where you stand on restitution. Do you understand that?
Yes, sir.
Okay. And is he supposed to be on supervision on both counts of 1347?
Yes, Your Honor.
All right. On count 2, I'll adjudicate you guilty. I'll sentence you to 162 days time served, followed by 18 months of supervised probation. The conditions of probation on count 2 are comply with all terms and conditions on count 1. I'm going to order that payment of your restitution be a condition of your probation. I'm going to talk about a payment plan at the end of this process. That is the sentence in 19 CF 1347. I am ordering restitution in the amount of $1,436 payable to the Home Depot. That takes us to 19 CF 1344. As to the single count, I'll adjudicate you guilty. In that case, I'm going to sentence you to 162 days in the Osceola County Jail with credit for 162 days time served. That'll be followed by 18 months of supervised probation, again with the conditions that you report to probation no later than 4 p.m. tomorrow, Wednesday, May 27th, 2020. While you're on probation, in that case, I'll also order that you comply with all the terms and conditions of probation that I announced in case number 19 CF 1347. In 19 CF 1344, I'm ordering that you pay $549 restitution to the Home Depot. That takes care of that case. Next is case number 19 CF 643. In that case, I'll adjudicate you guilty. I'll sentence you to 413 days in the Osceola County Jail with credit for 413 days time served. In that case, I'll order that you pay restitution in the amount of $2,900, is it 94 or 44?
$2,994.
$2,994 to the Home Depot, and I'll order that you pay cost of investigation in the amount of $360 to the St. Cloud Police Department, along with all statutory required fines, fees, and costs in that case. In 19 CF 645, I'll adjudicate you guilty and sentence you to 413 days in the Osceola County Jail with credit for 413 days time served. In that case, I will order restitution in the amount of $798 payable to Home Depot and cost of investigation in the amount of $268 payable to the St. Cloud Police Department. And again, all statutory required fines, fees, and costs in that case. That takes us to 19 CF 646. In that case, I will adjudicate you guilty. In that case, I'll sentence you to 413 days in the Osceola County Jail with credit for 413 days time served. Again, I'll order that you pay all statutory required fines, fees, and costs associated with that case, including restitution in the amount of $1,856 payable to the Home Depot, and cost of investigations payable to the St. Cloud Police Department in the amount of $130. Again, in each case, I'm going to order that you pay all statutorily required fines, fees, and costs. I'm also going to order in each case that you pay the restitution amounts previously announced, the cost of investigation amounts previously announced. In just a minute, I'm going to have the clerk announce the cost by case, and then at the end, I'm going to set up a payment plan. I will note that the sentence on each case and each count is concurrent with the others entered today. Madam Clerk, can you announce the cost, including restitution and cost of investigation by case number?
In case number 19 CF 1347, court cost is $415 with a $3 teen court fee, $100 cost of prosecution, $100 PD lien, $100 PD assistance fee, and restitution amount of $1,436 for a total of, in that case, of $2,154. In case number 2019 CF 646, court cost is $415, a $3 teen court fee, $100 cost of prosecution, $100 PD lien, $100 PD assistance fee, $130 cost of investigation, and restitution of $1,856 for a total of $2,704. In case number 2019 CF 643, court cost is $415 with a $3 teen court fee, $100 cost of prosecution, $100 PD lien, $100 PD assistance fee, cost of investigation of $360, cost of restitution of $2,994 for a total of $4,072 in that case. In case number 2019 CF 1344, court cost is $415 with a $3 teen court fee, $100 cost of prosecution, $100 PD lien, $100 PD assistance fee, and restitution amount of $549 for a total of $1,267. And in case number 19 CF 645, court cost is $415, $3 teen court fee, $100 cost of prosecution, $100 PD lien, $100 PD assistance fee, cost of investigation of $268, and restitution amount of $798 for a total of $1,516. And all totals combined are $11,713.
All right, sir. I'm going to order that your cost and your cases be consolidated into a single payment. Question, do you know if Foundations for Life is going to allow you to work at all while you're in the program?
Yes, sir, so it's a work program.
Okay. And how much do you think you'll be earning each week when you're in that program?
I'm not too sure at this time.
Okay. And one thing I need to put on your cases where you're on probation, you need to report to probation no later than 4 p.m. tomorrow. Have you talked to Foundations for Life about how quickly you can go to them and get enrolled in the program?
Your Honor, we've actually been in talks with Foundations for Life. They do not do pickups from the Osceola jail,
Right.
so Mr. Kelly has to make his way over there. But they do have a bed available for him. They told me that this morning. So as long as he calls them as soon as he gets out of the jail, he can claim that bed.
Okay. So, sir, I'm going to order as soon as you're released from custody that you contact Foundations for Life and immediately enter the program when they have a bed available and show proof to your probation officer that you've entered the program. I'm going to order that within 60 days of today's date, you begin making payments. I'm going to set your payments at $100 a month at this point in time. If you can pay more, I would recommend you do that. If you cannot pay $100 a month, then you need to file with the court a request to modify that. And you need to establish what you're actually making at that point in time. Do you understand?
Yes, sir.
All right. So within 60 days, $100 a month through probation. Now, here's what I'm going to order. I'm going to order if your 18 months runs and you still have an outstanding balance, that outstanding balance simply gets referred back to the clerk of the court collection program, and you'll continue to make payments at a minimum rate of $100 a month until your costs get paid in full. Do you understand?
Yes, sir.
All right. Ms. Rosas, anything else I need to do?
No, Your Honor.
Mr. Baird, anything else I need to do?
Nothing for the state.
Madam Clerk, anything else I need to do?
No, sir.
All right, that's the judgment and sentence of the court in Mr. Kelly's 5 cases. He may be released on those 5 cases only. Good luck to you, sir.
Thank you.
You're welcome. All right, so I think all that we have left is Ms. Rosas' plea with the interpreter. Is that correct?
It's a motion to set bond.
Our motion to set bond? Mr. Baird, are you ready to go on the motion?
Yes, Your Honor.
Just give me a moment. I'm going to pull the case up, and I'm going to see if I've got an interpreter. 2001. 2522. All right, gonna see if we have an interpreter.
Good morning, Your Honor. This is Ali Figueroa, State Certified Spanish Court Interpreter.
Good morning, Mr. Figueroa. This is Judge Wooten down in Division 201. Have you been sworn this morning?
Yes, Your Honor.
All right, we're going to call a case with an inmate in the Osceola County Jail. They're going to bring him up, and we'll make sure that they can hear you out at the jail. Let's go ahead and call up State of Florida versus Hernan Rios Rodriguez. And Mr. Figueroa, can you see the screen where the inmates are from your vantage point?
Let me check, Your Honor. Your Honor, if the inmate is at the jail, it will have to be done through the speaker. I don't
Okay.
have a way to connect directly to the jail.
Okay. He's now standing at the microphone in the Osceola County Jail. Can you confirm that he can hear you?
¿Me escucha, señor?
Sí.
He can hear me, Your Honor.
Let's go ahead and swear the defendant in.
Levanta la mano derecha, por favor.
You do solemnly swear or affirm the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth, so help you God?
Jura o promete que el testimonio que rendirá será la verdad, solo la verdad y nada más que la verdad. ¿Lo jura ante Dios?
Sí.
Yes.
Good morning, sir. Tell me your name and your date of birth.
Dígame su nombre, señor, y fecha de nacimiento.
Hernán Alessio Rodríguez, 26 de abril del 94.
¿Me repite el nombre, por favor?
26 de abril del 94.
El nombre.
Hernán Alessio Rodríguez.
Edgar Alessio Rodriguez, April 26 of 94.
Sir, you're here today for a bond hearing. You're currently in the Osceola County Jail on a violation of probation proceeding, and you currently have, I believe, no bond.
Señor, se encuentra aquí para una audiencia de fianza, para fijar fianza. Usted se encuentra en la cárcel del condado de Osceola ante una acusación de incumplimiento de libertad vigilada sin derecho a fianza en este momento.
Present in the courtroom is your public defender, Ms. Rosas, and the state attorney. Ms. Rosas, are you ready to proceed with the bond hearing?
Yes, Your Honor.
You may inquire of your client.
Okay.
Bien, presente acá en la sala están la señorita Rosa, la defensora pública, y la abogada fiscal. La señorita Rosa comenzará haciéndole una serie de preguntas.
Mr. Rios Rodriguez, how long have you lived in Central Florida?
Señor Ríos Rodríguez, ¿hace cuánto que usted está viviendo en el área central de la Florida?
8 años.
8 years.
And why did you move here?
¿Y por qué se mudó para acá?
Bueno, pues pensando en el futuro, me gusta más acá. Yo vengo de Puerto Rico y me gusta más aquí, quiero tener una buena vida.
Just thinking ahead of my future, I wanted to move here because I like being here better than in Puerto Rico. I moved here from Puerto Rico.
Do you have family in Central Florida?
¿Usted tiene familia aquí en el área central de la Florida?
Sí, tengo a mi abuela, a mi tío y tengo a mi mujer que nació el hijo hoy a las 5 de la mañana y por eso me confianza en de mí y yo siempre con
Yes, I have my grandmother, my uncle, and my wife. The baby was just born today at 5 a.m., which is why I'm asking to see if I can have a bond so I can go home and help out in whatever I can.
We're going to talk about the baby in a little bit, but so where does your family live in Central Florida?
Vamos a hablar sobre el bebé en un minuto. ¿Dónde vive su familia en el área central de la Florida?
2750 Loin Line 34744.
2750 Lowing Lane, 34744.
If you were released, is that where you would live?
Si usted quedara en libertad hoy, ¿ahí es donde usted iría a vivir?
Claro, sí.
Yes, of course.
Okay, and who else lives there with you?
¿Quién más vive allí con usted?
Nosotros solamente, mi tío, mi abuela y mi mujer y un bebé.
Just us, my uncle, my grandmother, my wife, and my baby.
Before you were arrested, did you have a job?
Antes de ser arrestado, ¿usted tiene un empleo?
Sí,
Yes,
un restaurante.
at a restaurant.
Where did you work?
¿Dónde trabajaba?
Aquí en Mellow Bakery.
At Melau Bakery.
How long had you been working at Malau?
¿Hace cuánto tiempo lleva usted trabajando en Melau?
Un año.
A year.
What did you do there?
¿Y qué hacía usted allí?
De cocinero.
Cook?
If you're released, do you know if Malau will take you back?
Si usted queda en libertad, ¿usted sabe si Melau lo contrataría de vuelta?
Sí, tengo. Sí, tengo trabajo de vuelta. Estamos en
Yes.
comunicación con los dueños y el dueño es el tío de mi mujer.
Yes, I would have my job back. I've been talking to the owners. The owner is my wife's uncle.
Now, Mr. Rios, you mentioned a baby. How many children do you have?
Señor Ríos, usted mencionó un bebé. ¿Cuántos hijos tiene usted?
Es el primero es mi primer hijo.
He's my first.
And when was this child born?
¿Y cuándo nació?
A las 5 de la mañana, hoy, el 26.
5 a.m. today, the 26th.
Okay. And is this the first child for you and for your wife?
¿Y este es el primer niño que tienen usted y su esposa?
Sí.
Yes.
Okay. And before you were arrested, did you plan on being there for your child's birth?
Y antes de ser arrestado, ¿usted planeaba estar ahí presente para el nacimiento de su niño?
Sí, yo quería estar ahí, pues claro.
Yes, I wanted to be there, of course.
So, can you just explain why is it important for you to be out of jail at this time?
¿Me puede explicar por qué es importante que usted salga de la cárcel en este momento?
Pues claro, que tengo que seguir trabajando y mantener a mis hijos y a mi mujer que dependen de mí. Ella no tiene más nadie, ella padece de epilepsia también, eso ella entiende la verdad importante.
Well, because I need to work so I can support my wife and my kid. I'm the only support they have. I'm the only family that she has here. She also suffers from epilepsy, so I need to be there for her.
Have you ever failed to appear?
¿Alguna vez usted ha faltado en comparecer a la corte?
¿Perdona?
I'm sorry?
Have you ever failed to appear at a court date?
¿Alguna vez ha faltado en comparecer en la corte cuando le ha tocado?
No, nunca, siempre he asistido puntual.
No, never. I've always been on time.
Okay. If you are released, will you come to all of your future court dates?
Si usted queda en libertad, ¿usted comparecería en todas las fechas que le toca?
Claro, sí.
Of course, yes.
If you are released, will you maintain contact with me?
Si quedara en libertad, ¿usted mantendría comunicación conmigo?
Sí.
Okay.
Yes.
And if your address changes, will you notify the court?
Y si usted cambia de dirección, ¿usted le notificaría al tribunal?
Sí.
Yes.
How much bond can you afford?
¿Cuánta fianza puede pagar usted?
100.
100.
I have no further questions.
Examination from the state?
La, fi-
Okay. Any,
la fiscalía le hará una serie de preguntas.
any other witnesses from the defense?
No, Your Honor. His wife was going to be here today, but for obvious reasons, she can't.
No hay más testigos de parte de la defensa. La esposa iba a estar presente, pero por razones obvias no pudo presentarse.
Any witnesses from the state?
No, Your Honor, no witnesses.
No hay testigos de parte de la fiscalía.
Argument in favor of granting the motion, Ms. Rosas?
Yes, Your Honor. We know that Mr. Rios Rodriguez is not entitled to a bond, given that this is a violation of probation. But we believe that his testimony today shows that he has significant ties to the community and that he is not a flight risk.
Su señoría, dado que esto es una acusación por incumplimiento de libertad vigilada, sabemos que el señor Ríos no tiene derecho a una fianza, pero hemos podido demostrar que él tiene vínculos significativos en la comunidad y que no está a riesgo de fugarse.
He has lived in Central Florida for about 8 years. He has several family members that live here, including grandparents, uncles, his wife, and now his newborn baby.
Él lleva viviendo en el área 8 años y tiene familiares viviendo aquí, tiene la abuela, el tío, la esposa y ahora recientemente también el hijo que acaba de nacer.
Before he was arrested, he had gainful employment at Malau Bakery, and he has spoken to the business owner there, and he is going to be able to get his job back over there.
Antes de ser arrestado, él tenía empleo, estaba trabajando en el Melao Bakery y se ha mantenido en comunicación con el dueño y tiene la oportunidad de regresar a trabajar cuando quede en libertad.
He also testified how important it is for him to be out of jail at this time because his wife just gave birth and she will need to be there taking care of the baby. And so his wife will not be able to work and he will need to provide for his family. And also his wife suffers from epilepsy, which is another reason why he needs to be there to help her.
Él nos ha explicado que es muy importante para él salir de la casa en este momento, ya que su esposa acaba de dar a luz a su bebé, por lo tanto la esposa no puede trabajar en este momento, tiene que cuidar al bebé y él es el que tiene que trabajar para poder mantener a su esposa y al bebé, ya que ella también sufre de epilepsia y no puede trabajar.
And he also testified that he has never failed to appear. He said that if he were released, he would come to all of his future court dates, stay in touch with his attorney, and also notify the court if his address changes.
Él también ha testificado que nunca ha faltado a comparecer al tribunal y que si queda en libertad, él se mantendría en comunicación con su abogada y que comparecería a todas las fechas futuras cuando le toque.
And finally, he testified that he could afford $100 towards a bond, so we're asking for a $1,000 bond in this case.
Y testificó que puede permitirse $100 para la fianza, así que estamos pidiendo en este momento que se emita una fianza de $1,000.
Argument in opposition from the state?
Your Honor, did the court take notice of the violation of probation amended affidavit in the court file?
I have.
All right, Your Honor. Based on the affidavit, the amended affidavit of violation of probation, we have a situation here where the defendant has been alleged to have committed not one but two separate offenses on two separate dates while on probation, the first occurring at the Millennium Mall, and then the second occurring at a Home Depot. Your Honor, this defendant has shown that he is flaunting and thumbing his nose at the rule of the court, at his order of probation, and the court should not trust him to return to a bond status at this time. There was no argument or testimony that I heard regarding the current COVID situation. If the court is considering that, I would point out that while almost everyone we've seen at the jail today has been wearing masks, the defendant is not wearing a mask at the jail, so that doesn't seem to be something at the forefront of his mind, and I don't think something that should be at the forefront of the court's mind in considering in this particular case whether the defendant should be released. I think the two violations of probation, both new laws on separate days, warrant the defendant be held no bond pending his VOP hearing.
Su señoría, dado el affidavit modificado que se presentó al tribunal esta mañana con respecto al incumplimiento de libertad vigilada, si vemos en el affidavit nos fijamos que hubieron dos ilícitos en dos fechas por separado. Uno fue en el Mall de Millenia, el otro fue en el Home Depot. Los dos ocurrieron en días diferentes mientras él se encontraba en libertad vigilada. Eso nos demuestra que él no tiene ningún respeto al tribunal, ni al Departamento de Libertad Vigilada, ni a la libertad vigilada en la que se encontraba. También quisiera hacer constar que, como se ve en las cámaras, las personas que están en la cárcel todas tienen las máscaras puestas y algunos están hasta usando guantes. El acusado ha decidido no usar ninguna máscara, demostrando que no tiene ninguna preocupación por la situación en la que estamos pasando, y dado el hecho que han sido dos incumplimientos bajo la libertad vigilada, la Fiscalía desea anunciar que no tiene derecho a quedar en libertad ni que se le emita fianza y que debe mantenerse encarcelado.
All right. Having heard all the testimony and reviewing the affidavit, I'm going to deny the request to set bond at this time. I do have concerns, given the allegations set out in the affidavit, as to how the defendant would comport himself if he were out on bond. Therefore, he'll remain on a no bond status pending disposition of his case. Do we have a violation of probation status date for the defendant?
Bien, dado lo que he leído en el affidavit, dado la audiencia de hoy, no concederé el pedimento de emitir una fianza, por lo tanto el acusado se mantendrá encarcelado sin derecho a fianza hasta que se tome una decisión con respecto al incumplimiento de la libertad vigilada. ¿Tenemos alguna actualización con respecto al estatus de la libertad vigilada y del incumplimiento?
Yes, it's set for July 2nd.
All right, the defendant is set for a violation of probation status hearing on July 2nd. We'll address this case then unless it's brought to the court for further action before that date.
Bien, hay una vista de seguimiento fijada para el 2 de julio con respecto al incumplimiento de la libertad vigilada. Trataremos el caso en ese momento, a menos que se radique otro pedimento antes de esa fecha.
Okay, that's the order of the court.
Esa es la orden. Gracias. Your Honor, may the interpreter get the case number?
2018 CF 2522.
Thank you, Your Honor.
All right, I believe that is the docket for the morning. Is that correct?
Yeah.
Osceola County Jail, do you have any subjects that you're expecting me to talk to?
Yes, sir. You have one more
Okay, tell me who it is.
Penado. He is
That was Mr. Seidel's case.
for a motion.
Okay, hold on one second. All right, tell me the defendant's name again.
It's Penado Poton Christopher case.
Okay. That case, the defense attorney was unable to secure the appearance of their witnesses, so that's going to be set for a new hearing.
Okay, thank you, sir.
Yep, all right, that's it. Thank you. Have a good day.
Have a good day.
All right, have a good day, Ms. Roses. You are welcome. Why am I getting, let's try that.
Appearance for state,
Maria Morales on behalf of the state.
appearance for defense,
Guillermo Lopez on behalf of the defense.
and PTR. All not.
PD approved.
Good afternoon, sir. State your name and date of birth, please.
Paul Knott, August 4th, 1967.
Thank you, Mr. Knott. You've been arrested on assault, simple, law enforcement officer, firefighter, EMT, and resisting or obstructing without violence. The court has reviewed the charging affidavit. I find that there's sufficient probable cause as to both charges. You're not to return to 91 Beehive Circle in St. Cloud, and bond will be set in the amount of $500 for each count. Thank you, sir.
Next court date is still in jail, June 4th. It filed July 6th in courtroom 4E at 8:15 a.m.
Julio Santiago Torrero.
PD approved.
It was 91 Beehive. in St. Cloud. Sir, if you'll give me just a moment, the victim is here. We're waiting for them to bring her in. Julio Santiago Torrero. The arrest warrant just has Santiago on it.
Good morning, this is Dalia. Good afternoon, this is Dalia Romero, Spanish interpreter on the line.
Hello again, Ms. Romero. It's 20 MM 1201. An interpretation is actually needed for the victim. Good afternoon, sir. State your name and date of birth, please.
Buenas tardes, señor. Díganos su nombre y fecha de nacimiento, por favor.
No, I speak English.
I understand, but we have to interpret everything for the victim.
Okay. Julio Santiago Torres.
Julio Santiago Torres. Your Honor, is the victim in a different courtroom?
No, she's in the courtroom here with us.
And you're in courtroom?
5F.
5F? Okay, thank you.
Do you want to try to do the headset?
Yes, I can try to do that, definitely.
Let me know if she can hear you.
One moment, please. It's not working, Your Honor. I can go ahead and do it over the loudspeaker.
Okay. It's not working.
Sorry.
Good afternoon, ma'am. Raise your right hand to be sworn, please.
Buenas tardes, señora. Levante su mano para prestar juramento, por favor.
Do you solemnly swear or affirm that the testimony you shall give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
¿Usted jura o afirma que el testimonio que va a estar presentando en esta tarde va a ser la verdad, toda la verdad y nada más que la verdad ante Dios? Yes.
Thank you. You can lower your hand.
Gracias. ¿Puede bajar su mano?
Sir, you've been arrested for battery, touch, or strike.
Señor, usted fue arrestado por agresión, por haber tocado o haberle golpeado.
The court has reviewed the charging affidavit. I find that there's sufficient probable cause.
La jueza ha repasado la affidavit acusatoria y halla que hay causas que respaldan la acusación.
Ma'am, state your name, please.
Su nombre, señora, por favor.
Yaritza Rivera.
Un poquito más fuerte, por favor.
Yaritza Rivera.
Yaritza Rivera.
And ma'am, what would you like me to consider as far as release conditions for Mr. Torres?
Señora, ¿qué es lo que usted quiere que yo tome en consideración como condiciones de libertad para el señor Torres?
No representa ninguna amenaza para mí, que todo fue un malentendido y esto está bien.
He does not present a threat to me. It was all a misunderstanding and everything is fine.
If something like this were to happen again, would you contact law enforcement?
Si algo como esto volviera a ocurrir nuevamente, ¿usted se comunicaría con la policía?
Sí.
Yes.
Sir, your bond is going to be set in the amount of $1,000.
Señor, su fianza va a ser de $1,000.
You're not to have any hostile contact with Yaritza Colon.
No puede tener ningún contacto hostil con Yaritza Colón.
Means if you feel an argument or a frustration coming on, it's in your best interest to leave, because if you don't, the police will be called and you're the one that's going to jail.
Lo cual quiere decir que si usted tiene alguna discusión o alguna frustración con ella, lo mejor para usted sería retirarse e irse, porque de lo contrario la policía va a ser llamada y usted va a ser arrestado.
You're not to return to 2860 Clipper Cove Lane, apartment 201 in Kissimmee.
I'm sorry, Your Honor, what is the apartment number?
2860 Clipper Cove Lane, apartment 201.
No puede regresar al 2860 Cove Lane, apartamento 201 en Kissimmee.
You can go back one time with the assistance of law enforcement to obtain your personal items only.
Puede regresar solamente en una ocasión acompañado de la policía para retirar sus artículos personales nada más.
You're not to possess or consume any alcohol or drugs.
No puede poseer ni consumir ningún tipo de drogas o alcohol.
You're not to possess any weapons or firearms.
No puede poseer ningún tipo de armas o armas de fuego.
Do you understand, sir?
¿Entiende esto, señor? Yes.
Thank you. Yes, ma'am.
Gracias.
¿Puedo hablar?
May I say something?
Yes, ma'am.
Sí, señora.
Que yo sí quiero tener contacto con él porque él no puede regresar a la casa.
I do want to have contact with him. Why can he not return to the house?
I've granted your request to have no hostile contact with him, but he is not to return to the house.
Yo le he permitido a usted, a él tener contacto con usted, pero no contacto hostil, pero él no puede regresar a vivir a la casa.
¿Hasta cuándo?
Until when?
Until further order of the court.
Hasta que la corte cambie esta orden más adelante.
If he wishes to have that changed, he can contact his lawyer and they can file the appropriate motion for a full evidentiary hearing.
Si él quiere cambiar esa condición, él se puede comunicar con el abogado para que hagan una audiencia, se pida una audiencia para cambiar las condiciones.
Thank you.
Gracias.
Next court date is still in jail, June 4th. It filed June 29th in courtroom 4A at 8:15 a.m.
Thank you, Mr. Torres.
Your Honor, the case number was 20MM 1201.
1201.
Thank you.
Francisco Pena.
PD approved.
Oh, I'm sorry, Ms. Romero. I think that's it. Isn't that it? Yeah? That's it. Thank you.
Okay, thank you. Bye-bye.
First start going on.
Good afternoon, sir. State your name and date of birth, please.
Francisco Rafael Peña, 11/25/1987.
Mr. Pena, you've been picked up on a warrant as a result of a violation of probation. The allegations are a failure to report, there's failure of payment for cost of supervision, failure of payment of court fines and court costs, failure to do your community service hours. I issued the warrant. The warrant was issued at no bond. I will, however, modify that and give you a $500 cash bond. I'll see you at your next court date.
Next court date, June 4th, in courtroom 5B at 8:05 a.m.
Jesse Smith,
PD approved.
good afternoon, sir. State your name and date of birth, please.
Jesse Smith, 4485.
Thank you, sir. Picked up on 2 charges. There's possession of controlled substance without a prescription, as well as possession or use of drug paraphernalia. Have reviewed the charging affidavit as well as the arrest warrant. I find that there's sufficient probable cause. It appears that you qualify for pretrial release, so the court will go ahead and order pretrial release. You are not to return to the U-Haul or South OBT and Durwood Street area. No alcohol, no drugs. Do you understand?
Yes, ma'am.
Next time might not be so beneficial for you.
No.
Thank you, sir.
Next court date, June 3rd, in courtroom 5A at 8:45 a.m.
Jason Astudillo,
PD approved.
Your Honor, we waive the formal reading of the charges.
Good afternoon, Judge.
Oh, never mind, Your Honor.
Richard Parker appearing on behalf of Mr. Jason Astudillo.
good afternoon, sir. State your name and date of birth, please.
Jason Astudillo, February 21, 1998.
Thank you. Counsel, do you want to waive the reading of the charges?
Yes, Your Honor, we would stipulate to a finding of probable cause as to the charging affidavit. Judge, we're going to be asking that the court set bond today at the standard bond. Mr. Astudillo does not have any prior record. I think he's currently 22 years of age. His entire family lives here in Osceola County. They're going to come meet with us this afternoon to secure representation for the entirety of the case. Judge, I do believe, based on the affidavit, that alcohol was a factor in this case. It is not an excuse or a defense, but it is a factor for the court to consider, given the fact that Mr. Astudillo has not had any prior record or anything of this nature in his past. Judge, we would ask that he be ordered to have no contact with the victim and stay at least 1,000 feet away from the victim's place of residence and work, and that he remained in Osceola County unless otherwise ordered by the court. Thank you.
Anything from the state?
No, Your Honor.
So let's be clear, there's not a standard bond. Each bond is addressed individually. I have reviewed the charging affidavit. I find there's sufficient probable cause. Bond to be set in the amount of $5,000. You're not to have any contact with Tyra Harrison. No contact means no in-person contact, no third-party contact, no social media contact, no telephone contact, no contact whatsoever. Do you understand?
Yes, ma'am. Yes, Your Honor.
You're not to go within 1,000 feet of her home or her work or any place that she would frequent. No alcohol, no drugs. Do you understand?
Yes, Your Honor.
Thank you, sir.
Thank you, Judge. May I be excused?
Yes, sir.
Have a great day.
Next court date on demand.
Miguel Cabrera Rodriguez,
PD approved.
good afternoon, sir. State your name and date of birth, please.
Good afternoon, Your Honor. Miguel Angel Cabrera Rodriguez, 1981.
Thank you, sir. You've been picked up on the charge of operating a motor vehicle without a valid driver's license. Court has reviewed the charging affidavit. I find there's sufficient probable cause. Going to release you on your own recognizance. Mr. Lopez, this is another MH one you might want to look into. Thank you, sir.
Thank you, Your Honor.
Next court date, July 6th, in courtroom 5B at 8:30 a.m.
James Cassidy,
PD approved.
Good afternoon, sir. State your name and date of birth, please.
James Cassidy, 11/11/1994.
Thank you, sir. You've been picked up as a result of battery, touch, or strike. The court has reviewed the charging affidavit. I find there's sufficient probable cause. Bond to be set in the amount of $1,000. You're not to have any contact with Amber Cassidy. No contact means no in-person contact, no third-party contact, no social media contact, no telephone contact, no contact whatsoever. Do you understand?
Yes, ma'am.
You're not to return to 6614 Osceola Polk Line Road. You may go back one time with the assistance of law enforcement to obtain personal items only. You're not to possess or consume any alcohol or drugs. Do you understand?
Yes, ma'am.
You're not to possess any firearms or weapons. Do you understand?
Yes, ma'am.
Thank you, sir.
Next court date is still in jail, June 4th. It filed July 6th in courtroom 5B at 8:30 a.m.
Alexis Cerezo.
PD approved, and the victim is outside, Your Honor.
Ray, does this qualify for PTR? There wasn't any notes on there.
No, Judge, he's a good.
Mr. Lopez, this is another. Good afternoon, ma'am. State your name and date of birth, please.
Nalita Miranda.
Sure.
Alexis Cerezo, June 19, 1999.
Thank you. Ma'am, can you raise your right hand, please?
Do you solemnly swear or affirm that the testimony you shall give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you. State your name, please.
Miranda. I have a trace, so right now it's bad.
Ms. Miranda, what would you like me to consider as far as release conditions?
Her condition, she has, Alexis has schizophrenia. She has anger management. And right now, she lives with me and I cannot have her with me at this moment.
Is there anything else you would like me to consider? Ma'am, you've been picked up as a result of battery, touch, or strike. The court has reviewed the charging affidavit. I find there's sufficient probable cause. Bond to be set in the amount of $500. You're not to have any contact with, is it Nalita? I'm sorry.
Nalita Miranda.
Miranda. No contact means no in-person contact, no third-party contact, no social media contact, no telephone contact, no contact whatsoever. Do you understand?
Yes, ma'am.
You're not to return to 1005 Wood Cove in Kissimmee. You can go back one time with the assistance of law enforcement to obtain your personal items. You're not to possess or consume any alcohol or drugs except for prescription drugs, and you may take those as prescribed. Do you understand?
Yes.
You're not to possess any weapons or firearms. Do you understand?
Yes.
Thank you, ma'am.
Next court date is still in jail, June 4th. It filed July 6th in courtroom 5B at 8:30 a.m.
Yolanda Gordon.
Ma'am, she's in medical. I had called to ask if she'd be seen last due to her condition.
Okay. I'll move her to the end. Thank you. Terrence Hudson, hospital.
When do you want to reach it?
When he's available. I mean, there's no sense in me telling you tomorrow if he's not out of the hospital yet, so whenever he's available.
The next one, Otero Marin, is also in the hospital.
And that one we will also reset for when he's available.
Patterson should be there.
Sorry, Your Honor, I'm sorry, what was that last one? Otero Marine?
Otero Marin, he's in the hospital as well.
All right, thank you, I'm sorry.
Welcome.
Frederick Patterson.
PD approved.
Good afternoon, sir. State your name and date of birth, please.
Frederick Richard Patterson, 5/19/1958.
Thank you, sir. You've been picked up as a result of driving under the influence of alcohol or drugs. The court has reviewed the charging affidavit. I find that there's sufficient probable cause. It appears that you qualify for pretrial release, so the court will do a direct pretrial release with the instructions of no consumption of alcohol or drugs. Do you understand?
Yes, Your Honor.
Thank you, sir.
Next court date, July 7th, in courtroom 4E at 8:15 a.m.
Alberto Rivera.
PD approved.
Good afternoon, sir. State your name and date of birth, please.
Alberto Rivera, 9/13/91.
Thank you, sir. You've been picked up as a result of possession of controlled substance without a prescription, to wit, methamphetamines, possession or use of drug paraphernalia, and trafficking of opium, 4 grams. Court has reviewed the charging affidavit. I find there's sufficient probable cause. Bond to be set on count 1 in the amount of $2,500, count 2, $500, count 3, $50,000. You're not to possess or consume any alcohol or drugs. I do also note that you are currently out on bond in 20 CT 96, which is a DUI. The court will be revoking that bond and setting a new bond in the amount of $1,500. On 20 CT 97, you're out on bond on that case as well. The court will not take any action on that particular case. Thank you, sir.
Next court date on demand.
Juan Rolón.
PD approved.
Good afternoon, sir. State your name and date of birth, please.
Juan Rowley, 10-2-70.
Thank you, sir. You've been picked up on a couple of matters. The first one is possession or use of drug paraphernalia and possession of heroin. The court has reviewed the charging affidavit. I find that there is sufficient probable cause. Count 1 will be set in the amount of $500. Count 2 will be set in the amount of $10,000. And I'm not sure how you have it on your paperwork, but the $10,000 is for the heroin, just so that we're clear.
Thank you.
You're not to possess any drugs or alcohol or consume any drugs or alcohol. Do you understand?
Yes, ma'am.
The next matter is carrying a concealed firearm and possession or weapon of a weapon or ammunition by a convicted felon. The court has reviewed the charging affidavit. I find that there's sufficient probable cause. Each count will be set in the amount of $2,500. You're not to possess any weapons or firearms. Do you understand?
Yes, ma'am.
That includes ammunition. Do you understand?
Yes, ma'am.
The third matter is violation of domestic violence injunction by possessing a firearm or ammunition. The court has reviewed the charging affidavit. I find that there's sufficient probable cause. Bond to be set in the amount of $1,000. You're not to possess any weapons or firearms. Do you understand?
Yes, ma'am.
Thank you, sir.
Next court date for 2020 CF 1489 and 1491 on demand, and for 2020 MM 1257. If still in jail, June 4th. If out, July 13th in courtroom 4A at 9:30 a.m.
Thank you.
Thank you. Jesse Schatz.
PD approved.
Good afternoon, sir. State your name and date of birth, please.
Jesse Schatz, 7/25/1992.
Thank you, sir. You've been picked up as a result of battery, simple touch, or strike. The court has reviewed the charging affidavit. I find that there's sufficient probable cause. Bond to be set in the amount of $1,000. You're not to have any hostile contact with Hilda Alberry. Am I saying that right?
Albury, yes.
Thank you, sir. So if you feel that you're starting to get aggravated, it's in your best interest to separate yourself from her, because if police are called, you'll be the one going to jail.
Yes, yes,
You're
ma'am.
also not to consume or possess any drugs or alcohol. Do you understand?
Yes, ma'am.
You're not to possess any weapons or firearms. Do you understand?
Yes, ma'am.
PTR, I note that there were children in the vehicle when all of this was taking place, but I did not see that DCF was contacted. DCF needs to be contacted regarding this matter.
DCF to be contacted.
Yes, sir. DCF is going to be notified of the situation, being that it took place in the presence of the minor children. I would suggest that you and your significant other conduct adult matters outside of their presence in the future.
Yes, ma'am.
Thank you, sir.
Next court date is still in jail, June 4th. If out, July 13th in courtroom 4A at 9 a.m.
Jerry Thompson.
He's in the hospital too.
He's in the hospital too?
No, he's He's present.
Okay.
Oh, that's what the jail told me.
Unless he was taken to the hospital while gone, but.
Is Mr. Thompson over there?
Do you want?
Mr. Thompson, we asked that he be reset. He's sick and medical now.
All right, we'll reset him for when he's available. I'm here all week, Thursday. Jeffrey Brown?
PD approved.
Good afternoon, sir. State your name and date of birth, please,
Good afternoon, Jeffrey Lynn Brown Jr.,
and your date of birth.
10/3/84.
Thank you, sir. Been picked up on a couple of matters. The first is possession of controlled substance without a prescription, to wit, heroin. The second is possession of controlled substance without a prescription, to wit, methamphetamines, and possession or use of drug paraphernalia. Court has reviewed the charging affidavit. I find that there is sufficient probable cause. Bond to be set on count 1 in the amount of $2,500, count 2, $1,000, count 3, $500. You're not to possess or consume any alcohol or drugs. Do you understand?
Yes, ma'am.
You're not to possess any weapons or firearms. Do you understand?
Yes, ma'am.
You put that there's 2 cases on here, but I only have 1. The second round is the exact charges.
That's his name charge.
He's being charged 2 different times.
I think they were the same. Difference in the numbers?
Yeah, that's how I think.
Oh, it is different facts. Mm-hmm.
Just exact.
Mr. Brown, you're also being charged with possession of controlled substance without a prescription, to wit, heroin, possession of controlled substance without a prescription, to wit, methamphetamines, and another possession or use of drug paraphernalia. We've just reviewed the charging affidavit. I find that there's sufficient probable cause. Bond to be set in the amount of $2,500 on count 1, $1,000 on count 2, $500 on count 3. You're not to possess any weapons or firearms. You're not to possess or consume any alcohol or drugs. Do you understand?
Yes, ma'am.
Also not to return to the area of West 192 and Siesta Lago Drive. Do you understand?
Yes.
If you're found in that area, you will likely be arrested. Do you understand?
Yes, ma'am.
Thank you, sir.
Next court date for 2020 CF 1493, 1494 on demand. Judge, did you want that no return on both orders? Or just the second?
Just the second one. The first one was regarding the tent.
Okay.
Did Yolanda Gordon ever make it? Okay. No worries. Just let me know when she gets there.
Okay, should be just a moment.
US West 192. afternoon, ma'am. State your name and date of birth, please.
Yolanda Gordon,
Your date of birth.
11/17/88.
Thank you, ma'am. You've been picked up as a result of battery, touch, or strike. The court has reviewed the charging affidavit. I find that there is sufficient probable cause. It appears that you qualify for pretrial release, so the court will grant you pretrial release. You're not to have any contact with the victim.
She lives in my house.
I understand that, but I'm not done.
Oh,
You're also not to return to 617 Elbridge Drive in Kissimmee. You can go back one time with the assistance of law enforcement to obtain your personal items, but during the pendency of this case, you are not allowed to reside there. Do you understand?
so I'm gonna be homeless?
You'll need to find other arrangements, ma'am.
Judge, if I may, she's being found positive for
So my
COVID.
family house.
We're asking for ROR due to health concerns. I don't know if that will change some of these conditions.
It won't change the conditions. I can't have her back in that house, and I'm not gonna have someone else kicked out because they're fighting over food. I mean, I can ROR, but she's still gonna have the same conditions. That way she doesn't have to report to you guys.
Well, it's the contact that we're worried about.
All right, I'll ROR. She won't need to report. Ma'am, you're not going to have pretrial release. I'm just going to release you on your own recognizance, but the no contact and no return still applies.
Next court date, July 7th, in courtroom 5B at 8:30 a.m.
Thank you.
My children are not here, but they're coming from New York, so what am I gonna do with my children?
I can't hear you. You need to speak into the microphone.
My children are not here, they're with my mom in New York, but that's our family home. So what I'm gonna do with my children, we gonna live in my car? I don't know anybody in Florida.
Ma'am, I can't help you with that. I've only made the conditions of your bond. You'll need to comply with them or you will get rearrested.
Okay,
Thank you.
can I go, my car is there.
I said you can go back one time with the assistance of law enforcement to obtain your personal items.
Okay, thank you.
All right, Gregory Lumley.
Yes, sir.
Good afternoon, sir. If you'll raise your right hand, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
State your name, please.
Gregory Thomas Limley.
All right, Mr. Limley, you are here today in Polk County Case 19 CF 5075. In this case, you were placed on probation for possession of methamphetamine, which is a third-degree felony, punishable by up to 5 years state prison, up to 5 years probation, and/or a fine of up to $5,000. And it also carries a mandatory 6-month driver's license suspension upon the entry of an adjudication of guilt. And you were placed on probation for possession of drug paraphernalia, which is a misdemeanor punishable by up to 1 year in the county jail, up to 1 year probation, and/or a fine of up to $1,000. Do you understand, sir?
Yes, sir, I do, sir.
Okay. You were accused of violating your probation. It's alleged that you violated Condition 1 by failing to report to the probation office on April 13th of 2020 as directed by your probation officer. It's alleged that you violated Condition 3 by moving from your last approved residence at 175 Mediterranean Court in Kissimmee on or about April 15th, 2020, again without prior approval of your probation officer. Do you understand, sir?
Yes, sir, I do.
Your Honor, I'm sorry to interrupt, but if we could pass this because there is no score sheet at this time, or we don't have a score sheet in our possession. And we're trying to work kind of behind the scenes to try to get it before the court.
Okay, well, let me finish the discussion with him, and we can hold off on sentencing until we get that resolved if necessary.
Thank you, Judge.
Mr. Limley, I've been provided a written admission form that tells me you want to resolve the case by entering an admission to the alleged violations. Is that what you want to do?
Yes, sir.
Okay. If you wish to enter an admission, this is an out-of-county and out-of-circuit case. That would require you to waive your rights to venue in Polk County in that circuit. Do you understand that?
Yes, I do, Your Honor.
And is that what you want to do?
Yes, in this case I do.
Further, if you enter admission, your probation can be revoked and terminated, and you could be sentenced to anything up to the maximum sentence you could have originally received. You understand?
I do understand, sir.
All right. Now, the admission form I have is not signed by you. Did you have a chance to read and sign a written admission form?
I have, Your Honor, sir.
Okay. Has he signed one, do you know? Or-
Yes, he should have it over there that we went over that exact
And
document.
hopefully that will be forwarded to us, and we'll have it for the court file, which we can forward to Polk County. Do you have any questions about anything on the written admission form?
No, I do not.
Are you currently under the influence of medication or any other drug or alcohol?
No, sir, I'm not.
Are you thinking clearly?
Yes, I am, sir.
Has any person coerced or forced you in any way to enter this admission?
No, I have not, sir. Been coerced.
Judge Jacobson in Polk County indicated that if you entered the admission, you should be adjudicated guilty of both counts, sentenced to 60 days in the county jail with credit for the time that you've already served, and financial obligations previously imposed will be reduced to a judgment. As I indicated, there would also be the 6-month driver's license suspension. Is that your understanding of the agreement?
Yes, it is, sir.
Has anyone promised you anything else?
No, they have not.
Now, you've been represented here in Osceola County by Mr. Mendoza with the Office of the Public Defender. Are you satisfied with his representation of you?
Yes, sir, I am.
Do you believe it is in your best interest to enter the admission?
At this time, I do, sir.
Very well. You do have the right to have a hearing to determine whether the state can prove that you did willfully violate your probation. If you elected to proceed to hearing, at your hearing, you could not be found guilty of any violation unless the state proved by the greater weight of the evidence that you did willfully violate your probation as alleged. Do you understand?
Yes, sir.
You would have the right to be represented throughout your hearing by your attorney, and you would have the right to confront and cross-examine witnesses who testified against you at the hearing. You would also have the right to present witnesses and evidence in your defense at the hearing. You have the right to have the court order any witnesses you had to be present so you could present their testimony. You further would have the right to testify yourself at the hearing. You understand?
Yes, I do, sir.
By entering an admission, you're giving up those rights, and the only hearing we will conduct in your case is a sentencing hearing. You also, by entering the admission, are waiving your right to appeal any matters relating to this case other than the jurisdiction of the court to hear your case and the legality of the sentence imposed. Do you understand?
Yes, sir.
All right. All right, I find that you are alert and intelligent, that you understand the nature of the allegations against you, the penalties you're facing, as well as the rights that you're giving up by entering the admission. I find that your decision to enter the admission has been freely and voluntarily made, and that you've had the advice of competent counsel with whom you've expressed satisfaction. So I'll accept the admission of violation of probation. If you'll have a seat, Mr. Lemley, we'll call you back hopefully shortly once we have a score sheet.
Thank you, sir.
You all able to pull up the old score sheet from Polk County?
That's what I've been trying all day, but their website keeps timing out on me.
Okay.
I'll continue to try and see what I can get.
Maybe you could email the PD's office there.
Yes, sir.
Maybe you'll.
Okay, let me see what I can do. Appreciate it.
All right, Adam Byrd.
Morning, Your Honor.
Good afternoon, Mr. Byrd. If you'll please raise your right hand and be sworn. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir, Your Honor, I do.
State your name, sir.
Adam Christopher Bird.
Mr. Byrd, in Orange County case 19 CF 5917, you were placed on probation for grand theft, which is a third-degree felony. punishable by up to 5 years state prison, up to 5 years probation, and/or a fine of up to $5,000. Do you understand?
I do, sir.
You're accused of violating your probation. It's alleged that you violated Condition 5 by committing the offense of trespass to an occupied structure or conveyance on or about January 28th of 2020 here in Osceola County. You understand, sir?
I do, sir.
If you admit that you willfully violated your probation can be revoked and terminated. You could be sentenced to up to 5 years state prison. Do you understand that?
Yes, Your Honor.
And do you wish to admit that you violated your probation as alleged?
I do, Your Honor.
All right, Mr. Byrd, similar to the prior gentleman, your case is an Orange County case. Now, while the court has jurisdiction in both counties, sitting as here in Osceola County, I normally would not have jurisdiction over your case pursuant to the administrative order entered by the Supreme Court. Since you are an out-of-county inmate and that we're not transporting inmates at the present time, I do have authority under the Supreme Court order to resolve the case if there's an agreed-upon resolution. But is it your desire to waive any issues regarding venue or jurisdiction of the court? Okay.
Yes, sir, Your Honor.
All right, I've been given a written admission form that appears to have your initials and signature on it. Did you read and sign the written admission form?
I did, Your Honor.
Do you have any questions about anything on the admission form?
No, sir, Your Honor.
Okay. Do we have the time served? This has 80 days credit, so. All right. Did any person coerce or force you in any way to enter the admission?
No, sir, they did not, Your Honor.
Your recommendation is that the court revoke and terminate your probation, sentence you to the 80 days in the county jail with credit for the 80 days that you've served.
Yes, sir, Your Honor.
Any outstanding financial obligations be ordered to be paid through the clerk's, the Orange County Clerk's Collection Program.
Yes, sir, Your Honor.
Are you satisfied with your lawyer?
I am, Your Honor.
You believe it's in your best interest to enter the admission?
I do, Your Honor.
Are you thinking clearly?
Yes, sir, I am, Your Honor.
You have the right to have a hearing to determine whether the state can prove that you did willfully violate your probation. If you chose to proceed to hearing, you would have the right to be represented throughout the hearing by your attorney. You would have the right to confront and cross-examine witnesses who testified against you. You would have the right to present witnesses and evidence in your defense at the hearing. You're entitled to use of the court's subpoena power to require any witnesses you have to be present at the hearing. You also have the right to testify yourself at the hearing. Since the alleged violation is that you committed a criminal offense while on probation, you could also choose to remain silent at the violation probation hearing. And you could not be found guilty of any violation unless the state proved to the satisfaction of the court or by preponderance of the evidence that you did willfully violate your probation as alleged. You understand?
I do, Your Honor.
By entering the admission, you're waiving the rights we've talked about as well as the other rights that are written on the admission form, and there won't be any further hearing in your case.
Yes, sir, Your Honor, I understand.
You also, by entering the admission, are waiving your right to appeal any matters relating to this case other than this court's jurisdiction to hear the case and the legality of the sentence imposed. Do you understand?
I do, Your Honor.
All right, I find that you're alert and intelligent, that you understand the nature of the allegations against you, the penalties you're facing, and the rights that you're giving up by entering the admission. I find that your decision to enter the admission has been freely and voluntarily made, and that you've had the advice of competent counsel with whom you say you're satisfied. So I will accept the admission of violation of probation. Does the defense have any objection to the score sheet submitted with 34.8 total sentence points?
No objection, Your Honor.
Is there anything further to be said before sentencing?
No, Your Honor.
Byrd, at this time I will revoke and terminate your probation. You were previously judged guilty of grand theft. This time you'll be sentenced to 80 days in the Osceola County Jail with credit for 80 days time served. pay the outstanding fine and court costs, as well as restitution of $318.09 to the Walmart store at 16313 Independence Parkway in Winter Garden. The money that's ordered to be paid to the Orange County Clerk's office. You are directed to contact that office within 30 days of today's date, set up a payment plan to pay the amount that you owe.
Sir, Your Honor.
Okay, you'll be released from the county jails to this case today. Have you resolved your other case here, or is that still pending?
No, sir, Your Honor. This is my last one to wrap up.
Excellent.
DOS on Tuesday.
Fair enough. All right, Mr. Byrd, you have 30 days to appeal. The judgment and sentence was just entered. If you wish to appeal and you're unable to afford to hire a lawyer, I will appoint one to represent you. If you do not file an appeal within 30 days of today's date, you waive your right to appeal. Do you understand?
I do, Your Honor.
All right. Good luck to
Thank
you.
you, sir. Have a blessed day.
Mario Brown.
Nicole Dupre on behalf of Mr. Brown.
All right, Mr. Brown, raise your right hand, sir. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
I do.
State your name, please.
Mario Brown.
All right, and, one moment. Mr. Brown, you were placed on probation in St. Lucie County in case 18MM 3093 for possession of 20 grams or less of cannabis and possession of drug paraphernalia, each of which is a misdemeanor punishable by up to 1 year in the county jail, up to 1 year probation, and/or a fine of up to $1,000. Do you understand?
Yes, sir.
Count one also carries a mandatory 6-month driver's license suspension upon the entry of an adjudication of guilt. Do you understand?
Yes, sir.
You're accused of violating your probation. It's alleged that you violated Condition 9 by unlawfully consuming marijuana or cannabis on or about January 8th of 2020. It's alleged that you violated Condition B by failing to submit to drug test on October 11th of 2019, November 21st, 2019, and December 3rd of 2019, as well as January 7th of 2020. It's alleged you violated Condition 2A by failing to report by mail to probation for the months of November and December of 2019 and January of 2020. It's alleged you failed to pay the fines and court costs as ordered, and that you failed to pay the cost of supervision as ordered. You understand what the allegations are?
Yes, sir.
If you admit that you willfully violated your probation can be revoked and terminated. You could be adjudicated guilty, sentenced to up to 2 years incarceration. There would be the 6-month driver's license suspension. You understand?
Yes, sir.
And do you wish to admit that you violated your probation as alleged?
Yes, sir.
And do you wish to waive any objection to this court's, to venue or this court's jurisdiction to hear your case?
No, sir.
You do not?
You said, do I wish to object?
Yes, no, I'm asking, in order for me to accept the plea, I want to know if you object to this court hearing it rather than the
No,
court.
no, 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 sir.
Okay, that's fine. All right. Now, Mr. Prim has submitted a written admission form. It does not have your signature on it. Have you gone over an admission form with your lawyer?
Yes, sir.
Did you understand everything on that form?
Yes, sir.
Do you have any questions about anything on the admission form?
No, sir.
Are you thinking clearly this morning?
Yes, sir.
Are you under the influence of any medication or other drugs or alcohol?
No, sir.
Did any person coerce or force you in any way to enter the admission?
No, sir.
Your recommendation is that the court revoke and terminate your probation. You would be adjudicated guilty of both counts and sentenced to the time that you've already served in this case. There'd be a 6-month driver's license suspension. Do you understand?
Yes, sir.
Are you satisfied with your lawyer?
Yes.
Do you believe it is in your best interest to enter the admission?
Yes.
You do have the right to have a hearing to determine whether the state can prove that you did willfully violate your probation. If you chose to proceed to hearing, at the hearing, you would have the right to be represented by your lawyer. You would have the right to confront and cross-examine witnesses who testified against you. You'd have the right to present witnesses and evidence in your defense. You have the right to have the court order any witnesses you have to be present at the hearing so you can present their testimony. You also have the right to testify yourself at the hearing, and you could not be found guilty of any violation unless the state proves by the greater weight of the evidence that you did violate your probation as alleged. Do you understand?
Yes, sir.
By entering the admission, you're waiving the rights we've talked about as well as the other rights that are written on the admission form, and there won't be any further hearing other than a sentencing hearing. You'll also be waiving your right to appeal any matters relating to your case other than this court's jurisdiction to hear the case. Do you understand?
Yes, sir.
There was a further condition of the agreement that you pay $100 cost of prosecution, and the court would order that that money plus any previously ordered money that's not been satisfied be paid through the clerk's office in St. Lucie County. Understand?
Yes, sir.
Does that change your decision to enter the admission?
No, sir.
Okay. Very well. Ms. Brown, I find that you're alert and intelligent, that you understand the nature of the allegations against you, you understand the penalties that you are facing, as well as the rights that you're giving up by entering the admission, and I find that your decision to enter the admission has been freely and voluntarily made, and you've had the advice of competent counsel. I'll accept the admission in violation of probation. Do we know what the time served is? Okay, so there's 11 days here.
Your Honor, I just wanted to, on Mr. Brown's case, this case was originally an NTA. At some point, there was a failure to appear, a warrant was issued, but it was recalled before it being served, so I believe the only credit time served is what we have here.
Yeah, fair enough. All right, then, is there anything further to be said before sentence is imposed?
No, Your Honor.
Okay. All right, Ms. Brown, I will follow the recommended disposition. I will revoke and terminate your probation. You will be adjudged guilty of possession of 20 grams or less of cannabis as charged in count 1 and possession of drug paraphernalia as charged in count 2. As to each count, you'll be sentenced to 11 days in the county jail with credit for the 11 days that you have already served. You'll be required to pay any outstanding financial obligations imposed in this case, as well as a $100 cost of prosecution to the clerk in St. Lucie County. I will direct that you contact the clerk within 30 days of today's date to set up a payment plan. Okay?
Yes, sir.
Your driving privileges are ordered suspended for a period of 6 months. The court has no objection to obtaining a business purposes license if you otherwise qualify, as soon as you might qualify. Do you have a driver's license at this time?
Yes, sir.
Okay. The driver's license suspension doesn't actually take effect immediately. The results of this plea will be forwarded to the Department of Highway Safety and Motor Vehicles, and they will suspend your driving privileges based on, after they've received that. So you should be okay to drive until you receive that notice. It is very important that they have your correct address. Is the address on your license where you receive mail right now, or do you need to change it?
I need to change it.
Okay. Make sure you change that as soon as you get out, otherwise they'll send you notice and you won't know when the suspension takes effect, and you wind up getting pulled over and arrested for suspended license.
Understood.
You don't need the additional headache. All right, you have 30 days to appeal. The judgment and sentence was just entered. If you wish to appeal and you're unable to afford to hire a lawyer, I will appoint one to represent you. If you do not file an appeal within 30 days, you waive your right to appeal. Do you understand?
Yes, sir.
All right, when you go, I would suggest that you go to the Department of Highway Safety and Motor Vehicles, if you find an office that's open, unless you go in person. Show them a copy of your paperwork, change your address on the license, and they may be able to tell you what you need to do or whether you'd be eligible for a business purposes license when that suspension takes effect. So, all right, good luck to you.
Thank you, sir.
Thank you. Any progress on Mr. Lemley?
Yes, sir. We did find a score sheet.
We found an old score sheet.
Okay.
But we don't have his violation of probation score sheet. We haven't heard anything from Polk.
Okay, well, if the old one, we just had 6 points to it, right?
That's what I thought, but, I want to make sure that the state was agreeable with that.
I mean, if the court's comfortable.
That's fine.
I inquired with Miss Allen, but I haven't heard anything.
And so did my superiors as well. We've all been kind of talking amongst email. And
Mr. Wickstrom is actually, he just CC'd me on a email with Polk County, and I guess they're going to be sending us an actual score sheet for the VOP. It just came into my inbox now. But
Is Mr. Lemley going to be in for a while, or is?
No, sir. According to my calculation, I think Thursday would be the release date. If we could potentially reschedule for either tomorrow or.
I'm doing.
I know we have
he's
pre-trial.
and 2 o'clock hearings on Thursday, so we can reset it for Thursday if you want.
Yes, sir.
Okay. Mr. Lemley, is he still there? Afternoon again, Mr. Lemley. We're having some difficulty getting a score sheet for you so we can proceed with sentencing. Mr. Mendoza indicates that he's calculated your release would be on Thursday of this week. So I'm going to reset the case for sentencing on Thursday. We'll have the score sheet. We can impose the sentence and hopefully get you out of there.
All right, thank you, sir. Your Honor. Thank you.
So we'll hold on to that. We'll call it Thursday at 2 o'clock.
Thank you, sir.
thank you, sir. Yeah. I don't see these guys. It's or Allen?
Okay.
O-O-R-R?
Yeah.
I think that it was just an order that was signed by the judge.
Mr. Ortiz and Mr. Hernandez.
Yes.
As to Justin Ortiz and Antone Hernandez, we still have not heard from Lake County. Have any of y'all heard from your counterparts?
I did receive an email on Mr. Hernandez's case. He has obtained private counsel, and they're on the midst of working out an agreement with Osceola and Lake County. So.
All right. Well, Mr. Ortiz and Mr. Hernandez at this time will remain on the bonds as previously set. And their counsel can schedule further proceedings as appropriate.
I'm sorry, Your Honor.
Yes, sir.
It's Anton Fernandez, and I'm not sure exactly what you said.
I actually said Hernandez, which is on the email I'm looking at, but it's Fernandez?
Yes,
Okay.
sir. It is Fernandez with an F.
I apologize, yes.
You're right.
You have a lawyer?
Yes, sir.
Who's your lawyer again?
I'm not sure. My dad have hired him.
His name is Hugo de Boban.
Hugo de Boban?
Yeah.
Okay. Mr. DeBobian hasn't filed anything with us. If you're able to get a hold of him, I'll be able to hear your case as soon as he's ready to proceed on it, so
Yes, sir.
you might want to
Yeah,
tell your,
I thought they were trying to get my VOP revoked and terminated, and then bond out from here, but,
okay, that may be the case, and,
yes, sir.
but at this point, I'll leave it up to Mr. DeBobian to schedule a hearing once he's got things worked out.
Yes, sir.
All right,
Yes, sir. Thank you, Your Honor.
Thank you. And the same with Mr. Ortiz. All right. All right, then, that being the case, I think that's all we have. Okay. Thank you, folks. We'll be in recess until tomorrow morning at 8:30 for